Passage number 24. Be ready? Comments. Mr. Deputy Chairman, this is an important bill and I welcome it heartily. It has always been the unanimous demand on the working class that there should be prevention of closures, lockouts and layoffs. This is an overdue measure. The Industrial Disputes Act is a very old piece of legislation and it requires a lot of changes. The proposed amendment will bring a great deal of relief to the working class. Sir, I would now like to make a few observations on the Industrial Disputes Amendment Bill. In this bill, a provision has been made whereby it will apply only to an establishment which employs 300 workmen. There is no rational basis for fixing this number of 300 workmen. It was the recommendation of the Indian Labour Conference that an establishment to which the provisions of the Industrial Disputes Act would apply should employ at least 50 persons. Subsequently, the Act was amended accordingly and 50 persons was the criterion for application of the provisions of the Industrial Disputes Act to an establishment. Now we have passed the bonus bill and reduced the qualifying number of employees in an establishment from 20 to 10. But in this very important bill, which will be the basis for rapid industrial production and industrial peace, we are stating that the number of employees in an establishment should be 300. I do not find any reasonable basis for arriving at this figure of 300. I would like the Honorable Minister to explain how this figure has been fixed in this legislation. I suggest that in order to have uniformity, this provision about the employment of 300 persons should be amended and it should be made 50. There are provisions in this bill according to which it is necessary to ask for permission prior to layoff or retrenchment or closure. But it is provided that no such notice is necessary if the retrenchment is under an agreement which specifies a date for termination of service. I think the old provision also requires modification in view of the policy of the government not to allow layoff or closure. It is necessary that such an agreement also should not be allowed to be made without the prior permission of the government. Such an agreement puts to an end the whole scheme and therefore it should not be permitted. Looking to the interests of the community as a whole, such an agreement should not be allowed to be made. The proviso is likely to be misused and therefore it requires vigilance on the part of the government. With regard to restarting of an undertaking which has already been closed down, the provision is that of restarting an undertaking which was already closed down otherwise than on account of unavoidable circumstances beyond the control of the employers and so on. The government can always come forward with a plea that the closure of an industry or an undertaking was due to unavoidable circumstances beyond the control of the employer. In a capitalist society in which we are living today with increasing concentration and monopolies, we find that many industries are closed down due to various obstacles, various deficiencies of the market and various defects in the production and distribution system. An employer can always argue that he had to close down the undertaking for reasons beyond his control. No employer has absolutely control or even partial control over the market which is the product of the working of the entire economic system. Therefore, it is easy for an employer to get away under the law on the plea of unavoidable circumstances. Such being the case, the provision should be so modified as to make it apply to all undertakings which have closed down for any reason. My next point is, in the case of industrial disputes, how to settle them. If disputes are settled at the proper time, all worries will be automatically solved and a situation of layoff or retrenchment will not arise. For this, I would suggest that joint management councils should be established in each industry and they should be given the responsibility of settling the industrial disputes arising in their respective industries. The aggrieved workers or the aggrieved union can bring forward their complaint to the joint management council and the joint management council can settle it. I think with their efforts at least 50% of the disputes will be solved in the very industry itself. If there is something left, then the appropriate government should keep a panel of top level mediators, not mediators of the ordinary caliber, but top level mediators, 3 or 4, but not more than that, to whom the disputes can be referred. This way, I think the disputes will come down to a great extent. These mediators should try to settle the disputes by moving both the employer and the employees. If any dispute is still left, it should go for arbitration. If something more is left, then it should go to the court and we have to solve the problem. Stop.